Hello everyone, Keith here, back with the video. Today for you guys, I'm going to be reading the National Currency Act, later called the National Bank Act. It's a very important document I'd like you guys to read. I'll leave a link to it down in the description below, along with our email. You can email us at thebonzi@gmail.com for private consultation. And yeah, let's get right into it. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that there shall be established in the Treasury Department a separate bureau, which shall be charged with the execution of this and all other laws that may be passed by Congress representing the issue and regulation of a national currency secured by the United States bonds. The chief officer of the said bureau shall be denominated the Comptroller of the Currency, and shall be under the general direction of the Secretary of the Treasury. He shall be appointed by the President on the recommendation of the Secretary of the Treasury, by and with the advice and consent of the Senate, and shall hold his office for the term of 5 years, unless sooner removed by the President, upon reasons to be communicated by him to the Senate. He shall receive an annual salary of $5,000. He shall have a competent deputy appointed by the Secretary, whose salary shall be $2,500, and who shall possess the power and perform the duties attached by law to the office of the Comptroller during a vacancy in such office and during his absence or inability. He shall employ from time to time the necessary clerks to discharge such duties as he shall direct, which clerks shall be appointed and classified by the Secretary of the Treasury, in the manner now provided by law. Within 15 days from the time of notice of his appointment, the Comptroller shall take and subscribe the oath of office prescribed by the Constitution and laws of the United States, and he shall give to the United States a bond in the penalty of $100,000, with not less than 2 responsible sureties, to be approved by the Secretary of the Treasury, conditioned for the faithful discharge of the duties of his office. The Deputy Comptroller so appointed shall also take the oath of office prescribed by the Constitution and laws of the United States, and shall give a like bond in the penalty of $50,000. The Comptroller and Deputy Comptroller shall not, either directly or indirectly, be interested in any association issuing national currency under the provisions of this Act. Section 2. And be it further enacted that the Comptroller of the Currency, with the approval of the Secretary of the Treasury, shall devise a seal with suitable inscriptions for his office, a description of which, with a certificate of approval by the Secretary of the Treasury, shall be filled in the office of the Secretary of the State, with an impression thereof, which shall thereupon become the seal of office of the Comptroller of the Currency, and the same name be renewed when necessary. When certificate, assignment, and conveyance executed by the Comptroller, in pursuance of any authority conferred on him by law, and sealed with his seal of office, shall be received in evidence in all places and courts whatsoever, and all copies of papers in the office of the Comptroller, certified by him and authenticated by the said seal, shall in all cases be evidence equally and in like manner as the original. An impression of such seal directly on the paper shall be as valid as if made on wax or wafer. Section 3. And be it further enacted that there shall be assigned to the Comptroller of the Currency by the Secretary of the Treasury suitable rooms in the Treasury building for conducting the businesses of the Currency Bureau, in which shall be safe and secure fire-proof vaults, in which it shall be the duty of the Comptroller to deposit and safely keep all the plates not necessarily in the possession of the engravers and printers and other valuable things belonging to his department. And the Comptroller shall from time to time furnish necessary furniture, stationery, fuel, lights, and other proper conveniences for the transaction of the said businesses. Section 4. And be it further enacted that the term United States bonds as used in this act, shall be construed to mean all registered bonds now issued, or may hereafter be issued on the faith of the United States by the Secretary of the Treasury in pursuance of law. Section 5. And be it further enacted that associations for carrying on the businesses of banking may be formed by any number of persons, not less in any case of 5, who shall enter the Articles of Association, which shall specify in general terms the object for which the association is formed, and may contain any other provisions not inconsistent with the provisions of this act, which the association may see fit to adopt for the regulation of the businesses of the association and the conduct of its affairs, which said articles shall be signed by the persons uniting to form the association, and a copy of them forwarded to the Comptroller of the Currency, to be filled and preserved in his office. Section 6. And be it further enacted that the persons uniting to form such associations shall, under their hands, make an organization certificate, which shall specify, first, the name assumed by such association, which name shall be subject to the approval of the Comptroller. Second, the place where its operations of discount and deposit are to be carried on, designating the state, territory, or district, and also the particular country and city, town, or village. Third, the amount of its capital stock and the number of shares into the same shall be divided. Fourth, the names and places of residence and the shareholders and the number of its shares held by each of them. Fifth, a declaration that said certificate is made to enable such persons to avail themselves of the disadvantages of this act. The said certificate shall be acknowledged before a judge of some court of record or notary public, and such certificate, with the acknowledgment thereof authenticated by the seal of such court or notary, shall be transmitted to the Comptroller of the Currency, who shall record and carefully preserve the name in his office. Copies of such certificate, duly certified by the Comptroller, and authenticated by his seal of office, shall be legal and sufficient evidence in all courts and places within the United States or the jurisdiction of the government thereof, of the existence of such association, and of every other matter or thing which could be proved by the production of the original certificate. Section 7. And it be further enacted that no association shall be organized under this act with a less capital than $100,000, nor in a city whose population exceeds 50,000 persons, with a less capital than $200,000, provided that banks with a capital of not less than $50,000 may, with the approval of the Secretary of the Treasury, be organized in any place of the population of which it does not exceed 6,000 inhabitants. Section 8. And be it further enacted that every association formed pursuant to the provisions of this act shall, from the date of the execution of its organization certificate, be a body corporate, but shall transact no business except such as may be incidental to its organization and necessarily preliminary, and until authorized by the Comptroller of this organization certificate, for the period of 20 years from its organization, unless sooner dissolved according to the provisions of its Articles of Association, or by the act of its shareholders owning 2/3 of its stock, or unless the franchise shall be forfeited by a violation of this act. By such name it may make contacts, sue and be sued, complain and defend, in any court of law, and equally as fully as natural persons. It may elect or appoint directors, and by its board of directors appoint a president, vice president, cashier, or and other officers, define their duties, require bonds of them, and fix the penalty thereof. Dismiss and offset officers, or any of them at pleasure, and appoint others to fill their places, and exercise under this act all such incidental powers shall be necessary to carry on the business of banking by discounting and negotiating promissory notes, drafts, bills of exchange, and other evidences of debt, by receiving deposits, and buying and selling exchange, coin and bullion, by loaning money on personal security, by obtaining, issuing, and circulating notes according to the provisions of this Act, and its Board of Directors shall have the power to define and regulate by bylaws not consistent with the provisions of this Act, the manner in which its stock shall be transferred, its directors elected or appointed, its officers appointed, its property transferred, its general businesses conducted, and all the privileges granted by this Act to associations organized under it shall be exercised and enjoyed, and its usual business shall be transacted at an office or banking house located in the place specified in its organization certificate. Section 9. And be it further enacted that the affairs of every association shall be managed by not less than 5 directors, one of whom shall be the president. Every director shall, during his whole term of service, be a citizen of the United States, and at least 3/4 of the director shall have resided in the state, territory, or district in which such association is located 1 year next preceding their election as directors, and be residents of the same during their continuance in office. Each director shall own, in his own right, at least 10 shares of the capital stock of the association of which he is a director. Each director, when appointed or elected, shall take an oath that he will, so far as the duty devolves on him, diligently and honestly administer the affairs of such association, and will not knowingly violate or willingly permit to be violated any of the provisions of this Act, and that he is a bona fide owner in his own right, the number of shares stock required by this Act, subscribed by him, or standing in his name on the books of the association, and that the same is not hypothecated or in any way pledged as security for any loan or debt, which oath subscribed by himself and certified by the officer whom it was taken shall be immediately transmitted to the comptroller of the currency, and by him filed and preserved in his office. Section 10. And be it further enacted that the directors of any association first elected or appointed shall hold their places until the successors shall be elected and qualified. All subsequent elections shall be held annually on such date in the month of January, as may be specified in the Articles of Association, and the directors so elected shall hold their places for 1 year, until the successors are elected and qualified. But any director ceasing to be the owner of the requisite amount of stock, or having any other manner become disqualified, shall thereby vacate his place. Any vacancy in the board shall be filled if no newspaper is published in such city, town, or country. Such notice shall be published in a newspaper published nearest thereof. If the articles of the association do not fix the day on which the election shall be held, or if the election should not be held on the day fixed, the day for the election shall be designated by the Board of Directors by their laws, or otherwise, provided that if the directors fail to fix the day as foresaid, shareholders representing the 2/3 of the shares may. Section 11. And be it further enacted that in all elections of directors and in deciding all questions at meetings of their shareholders, each stockholder shall be entitled to vote on each share of stock held by him. Shareholders may vote by proxies duly authorized in writing, but no officer, clerk, teller, or bookkeeper of such association shall act as proxy, and no shareholder whose liability is past due and unpaid shall be allowed to vote. Section 12. And be it further enacted that the capital stock of any association formed under this Act shall be divided into shares of $100 each, and be deemed personal property and transferable on the books of the association in such manner as may be prescribed in bylaws or articles of association, and every person becoming a shareholder by such transfer shall, in proportion to his shares, succeed to all the rights and liabilities of the prior holders of such shares, and no change shall be made in articles of association by which the rights, remedies, or security of the existing creditors of the association shall be impaired. The shareholders of each association formed under the provisions of this Act, and of each existing bank or banking association that may accept the provisions of this Act, shall be held individually responsible, equally and ratably, and not one for another, for all contracts, debts, and engagements of such association, to the extent of the amount of their stock therein at the par value thereof, in addition to the amount invested in such shares, except that shareholders of any banking association now existing under state laws, having not less than $5 million in capital actually paid in, and a surplus of 20 per centium on land, both to be determined by the comptroller of the currency, shall be liable only to the amount invested in their shares, and such surplus of 20 per circum shall be kept undiminished, and be in addition to the surplus provided for in this act. And if any time there shall be a deficiency in said surplus of 20 per centium, the said banking association shall not pay for any dividends to its shareholders until such deficiency shall be made good. And in case of such deficiency, the comptroller of the currency may compel said banking association to close its businesses and wind up in its affairs under the provisions of this act. And the comptroller shall have authority to withhold from an association his certificate authorizing the commencement of business, whenever he shall have reason to suppose that the shareholders thereof have formed the same for any other legitimate objects contemplated by this act. Section 13. And be it further enacted that it shall be unlawful for any association formed under this act by articles of association to provide an increase of capital from time to time, as may deemed expedient, subject to limitation of this act, provided that this maximum of such increase in the articles of association shall be determined, transmitted by the comptroller of the currency, and a certificate obtained specifying the amount of such increase of capital stock, with his approval thereof, and has been duly paid as part of the capital of such association. And every association shall have power, by the vote of shareholders owning 2/3 of its capital stock, to reduce the capital of such association to any sum not below the amount required by this act, in the formation of associations, provided that by no such reduction capital shall be brought below the amount required by this act for its outstanding circulation, nor shall any such reduction be made until the amount of the proposed reduction has been reported to the comptroller of the currency and his approval thereof obtained. Section 14. And be it further enacted that at least 50 per centium of the capital stock of every association shall be paid in before it shall be authorized to commence businesses, and the remainder of the capital stock of such association shall be paid in installments of at least 10 per centium, each on the whole amount of the capital, as frequently as one installment at the end of each succeeding month from time to time. It shall be authorized as by the comptroller to commence businesses, and the payment of each installment shall be certified to the comptroller under oath by the president or cashier of the association. Section 15. And be it further enacted that if any shareholder or his assignee shall fail to pay any installment on the stock when the same is required by forging section to be paid, the directors of such association may sell the stock of such delinquent shareholder at public auction, having given 3 weeks previous notice thereof in a newspaper published of general circulation in the city or country where the association was located. And if no newspaper published in said city or country, then in a newspaper published nearest thereof, to any person who will pay the highest price therefor, and not less than the amount due therein, then with the expenses of advertisement and sale, and the advertisement and sale, the amount previously paid shall be forfeited to the association, and such stock shall be sold as the directors may order, within 6 months from the time of such forfeiture. And if not sold, it shall be cancelled and deducted from the capital stock of the association. And if such cancellation and reduction shall reduce the capital of the association below the minimum of capital required by this act, the capital stock shall, within 30 days from the date of such cancellation, be increased to the requirements of the act, in default of which a receiver may be appointed to close up the businesses of the association according to the provisions of the 15th section of this act. Section 16. And be it further enacted that every association, after having complied with provisions of this act, preliminary to the commencement of banking businesses under its provisions, and before it shall be authorized to commence businesses, shall transfer and deliver to the Treasurer of the United States any United States registered bonds bearing interest to the amount not less than $30,000 nor less to 1/3 of the capital stock paid in, which bonds shall be deposited with the Treasurer of the United States, and by him safely kept in his office until the same shall be otherwise to be disposed of, in pursuance of the provisions of this Act. And the Secretary of the Treasury is hereby authorized to receive and cancel any United States coupon bonds, and to issue in thereof registered bonds of like amount, bearing a like rate interest and having the same time to run. And the deposit of bonds shall be, by every association, increased as its capital may be paid up or increased, so that every association shall at all times have on deposit with the Treasurer registered United States bonds to the amount of at least 1/3 of its capital stock actually paid in, provided that nothing in this section shall prevent an association that may desire to reduce its capital or to close up its businesses and to solve its organization from taking up its bonds upon returning to the Comptroller its circulation notes in the proportion hereinafter named in this Act, nor from taking up any excess of bonds beyond 1/3 of its capital stock, and upon which no circulating notes have been delivered. Section 17. And be it further enacted that whenever a certificate shall be has been transmitted to the Comptroller of the Currency, as provided in this Act, and the association transmitting the same shall notify the Comptroller that at least 50% of its capital stock has been paid as aforesaid, and such associations as complied with all the provisions of this Act required to be complied with such for such associations shall be authorized to commence in the businesses of banking. The Comptroller shall examine into association and the amount of the capital stock which has been each is the bona fide owner, and generally wherever such association has been complied with all requirements of this Act, to entitle that if no newspaper is published in such city or country, the certificate shall be published in a newspaper published nearest thereof. And be further enacted that the entire amount of notes for circulation to be issued under this Act shall not exceed $300 million. In order to furnish suitable notes for circulation, the Comptroller of the Currency is hereby authorized and required, under the direction of the Secretary of the Treasury, to cause plates and dies to be engraved in the best manner to guard against counterfeiting and fraudulent alterations, and to have printed therefrom and number such quantity of circulating notes in blank, the denominations of the dollar, $2, $3, $5, $10, $20, $50, and $100, $500, and $1,000, to be required to supply under this Act. The associations entitled to receive the same, which notes shall express upon the face that they are secured by United States bonds, deposited with the Treasurer of the United States by the written or engraved signatures of the Treasurer and Register, and the imprint of the seal of the Treasury, and shall also express upon the face of the promise of the association receiving the same pay on demand, attested by the signatures of the President or Vice President and Cashier, and the said note shall bear such devices and other statements, and shall be in such form as the Secretary of the Treasury shall, by regulation, direct, provided not more than 1/6 part of the notes furnished into an association shall be of less denomination than $5, and that after special payment shall be resumed, no association shall be furnished with notes of less denomination than $5. And be it further enacted that after any such association shall have caused its promise to pay notes on demands to be signed by the President or Vice President and Cashier thereof, in such manner as to make them obligatory promissory notes, payable on demand at its place of businesses, such association hereby authorized to issue and circulate the same as money, and the same shall be received at par in all parts of the United States in payment of taxes, excises, public lands, and all the dues to the United States, except for duties on imports, and also for all salaries and other debts and demands owing by the United States to individuals, corporations, and associations within the United States, except interest on the public debt, and in redemption of the national currency. And no such association shall issue post notes or any other notes to circulate as money than such are authorized by the foregoing provisions of this Act. And further be enacted that it shall be the duty of the Comptroller of the Currency to receive worn out or mutilated circulating notes issued by any such banking association, and also on due proof of the destruction of any such circulating notes, to deliver in place thereof to such association other blank circulating notes to an equal amount, and such worn out or mutilated notes after memoriam shall have been entered in the proper books, in accordance with such regulations as may be established by the Comptroller, as well as all circulating notes which shall have been paid or surrendered or to be cancelled, shall be burned to ashes in the presence of 4 persons, one to be appointed by the Secretary of the Treasury, one by the Comptroller of the Currency, one by the Treasurer of the United States, and one by the Association, under such regulations as the Secretary of the Treasury may prescribe. And a certificate of such burning, signed by the parties so appointed, shall be made in the books of the Comptroller, and a duplicate thereof forwarded to the Association, whose notes are thus cancelled. Section 25. And be it further enacted that it shall be the duty of every banking association having bonds deposited in the office of the Treasury of the United States once or oftener in each fiscal year, and such a time or times during the ordinary business hours as said officer or officers may select, to examine and compare the bonds so pledged with the books of the Comptroller and the accounts of the association, and if found correct, to execute the said treasurer a certificate setting forth the different kinds and the amounts thereof, and the same are in the possession and custody of the treasurer at the date of such certificate. Such examination may be made by an officer or agents of such association, duly appointed in writing for that purpose, whose certificate before mentioned shall be of like force and validity as if executed by such a president or cashier, and a duplicate signed by the treasurer shall be retained by the association. Section 26. And be it further enacted, this is the last one I wanted to do, that the bonds transferred and deposited with the Treasury of the United States, as hereinbefore provided by any banking association for the security of circulating notes, shall be held exclusively for that purpose, until such notes shall be redeemed, except as provided in this Act. But the Comptroller of this currency shall give to any such banking association powers of attorney to receive and appropriate to its own use the interest on the bonds, which it shall have transferred to the treasurer. But such powers shall come in and operative whenever such banking association shall fail to redeem its circulating notes as foresaid. Whenever the market or cash value of any bonds deposited with the Treasury of the United States, as foresaid, shall be reduced below the amount of circulation issued for the same. The Comptroller of the Currency is hereby authorized to demand and receive the amount of such depreciation in any other United States bonds at cash value, or in money from the association receiving said bills, to be deposited with the Treasury of the United States as long as such depreciation continues. And said Comptroller, upon the terms prescribed by the Secretary of the Treasury, may permit an exchange to be made of any of the bonds deposited with the Treasurer by association for other bonds of the United States, authorized by this Act to be received as security for circulating notes, if he shall be of opinion that such an exchange can be made without prejudice to the United States, and he may direct the return of any said bonds to the banking association which transferred the same, in sums of not less than $1,000 upon the surrender to him, and the cancellation of prorated amount of such circulating notes, provided that the remaining bonds which shall have been transferred by the banking association offering to surrender circulating notes shall be equal to the amount required for the circulating notes not surrendered by such banking association, and the amount of bonds in the hands of the treasurer shall not be diminished below the amount required to be kept on deposit with him by this act, and provided that there shall have been no failure by such association to redeem circulating notes, and no other violations by such association by the provisions of this act, and the market of cash value of the remaining bonds shall not be below the amount required for the circulation issued for the same. Alright guys, I'm ending it off here. I'll leave this link down in the description below for you guys to check it out. It's really important. You guys should really read it. Along with our email, you can email us at themoney@gmail.com for private consultation. And yeah, I'll see you guys in the next video. Have a nice day. Goodbye.